I mean, the unseeming part of the whole story is that this is not atypical of a way a case moves through the state court system. From the side of the judges and the clerk's office and the state attorneys and public defenders, the number of cases that run through the system are just enormous, and they range everywhere from misdemeanor batteries and thefts all the way up through first-degree homicides. And they're all funneling through the same courtrooms. And the caseloads are tremendous. So what happens on cases that are sort of stuck in the middle, that's not to say they're any less severe than any other case, but they're paid a little bit less attention than the cases that are either high profile or first-degree murder cases where they're concentrating on getting those and resolving those and getting them off the docket. As a result, most of these cases resolve by the way of a plea. And the cases in the middle that are sort of somewhere in between grand theft or petty theft and the first-degree murder, they continue to get continued. The defense attorneys are seeking to take depositions, they're seeking to go over discovery, they're conducting their own investigations outside of the courtroom. The prosecution has already received all the evidence, they've turned it over to the defense, and they're trying to get ready not for just 1 or 2 cases every week, but literally there are hundreds of cases that are set for trial on every Monday, or if it's a holiday, every Tuesday when you're running through the courtroom. So it's not unusual for a defendant, through his attorney, to request a continuance, and for the judge to just routinely grant it. Now, so that'll give you perhaps 4, 5, or 6 continuances, and this is in state court. In federal court, the cases are much quicker to process through the system. The volume is lower. There are no discovery depositions that are taken, and judges move their docket, and they move it fast because they want to get those cases off of their docket, because you have people who are incarcerated who are losing their liberty as the case progresses. So in the state court system, people whose cases are incarcerated move quicker through the system because of the same factors that are at work in the federal system. People who are out on bond, people who are continuing to just move their case along, they have no incentive for their case to go to trial, because as cases get older, people's memories fade. And the judges are more concerned with making sure that an incarcerated defendant has his or her case brought to trial. So again, not uncommon for there to be perhaps a half a dozen or even 7 or 8 continuances, and for a case to stretch on for 2 years. But when you showed me the docket from this case, you're talking about 33 defense continuances. 33 different times that this defendant came before the court, either by paper on a motion or physically showed up there with his attorney and said, "Judge, I need more time to investigate what's going on. I need more time for the case to proceed." And the judge granted the continuance. I didn't look to see how many different judges rotated through this division, but 33 times is a little bit excessive. And at that point in time, the victim's voice is lost, because the victim is not there. They're continuing to get standby subpoenas. They're told, "We're not going to forget about you. We're not going to let this case go away." But that's what the defense hopes. The defense hopes that eventually the victim says, "You know what, enough already. Go ahead and resolve it by the way of a plea. Sure, at the time that it occurred, very serious matter to me. I wanted the maximum penalty involved. This person needed to go to jail. They needed to be punished." Well, 33 continuances and what, 4, almost 5 years later, if the victim isn't as strong of an advocate for their case as they were in the beginning, the prosecutor is now going to start handing out a plea that's a lot more likable by the defendant than it is by the victim, and the victim is of the opinion, "You know what, enough already." As often happens in a case like this, the victim doesn't even live here anymore. So now they're going to have to bring them back down for a deposition, they're going to have to bring them back down for a case, and it's frustrating to the victims in these cases to hear that it's continued, and in some ways it's almost as if the system values the rights of a defendant over the right of a victim. So it's frustrating, and I can understand the frustration, having been on both sides, from both the prosecutors, from the defense attorneys. Ultimately, whether we want to believe it or not, what the system is really all about is seeking justice, but justice for both the defendant and the victim. So the victim has every right to be outraged about what's going on here. As far as the defendant goes, his lawyer's doing their job. They're trying to get this case ready to go to trial, because if it does go to trial, the last thing you want to do is be unprepared. You want to have everything that's available to you to refute the allegations that are being made, to present a defense. But again, 33 continuances over the course of 4 to 5 years, that's excessive. At some point, the judge has to step in and say, enough is enough. You've had plenty of time to get ready. You've done everything you need to do. I'm going to specially set this case for trial. It is going to be number one on my docket, and we're going to go to trial. Or you're going to resolve it by the way of a plea, and that's the end of it. So here's your fair warning. Here's the special set. I'm not going to do it tomorrow. I'm going to give you some time. And that's what needs to be done in this particular instance. The judge needs to take control of his or her calendar, and they need to just set this case and resolve it and have either a jury decide or have the state, with the input of the victim, decide what the appropriate punishment is on this part. Judges are elected officials in this state. The electorate needs to know what's going on. Volume is high, but there comes a time at 33 continuances where enough is enough. So that is something where the court has to become actively involved, and that's really the only way to end the frustration for the victim in this case, and that being the victim of the aggravated battery. Now, there are other victims involved with this particular defendant, and without passing judgment on the defendant or the victims or the investigation conducted by the police agencies with regard to this, there's another set of victims who sort of feel left out. Nobody paid attention to what was going on. In financial fraud cases, those are often among the most difficult for prosecutors to prove, whether it's in the state or whether it's in the federal system. Because here you're talking about an economic loss that was suffered by a victim, in the particular case, at the hands purportedly of a defendant. And in our system, the defendant is presumed innocent until proven guilty, so the burden of proof is on the prosecution in these cases. They not only have to prove that the defendant committed some particular act, but in these financial cases, they have to prove that it was done with criminal intent. And in a case like this, they have to prove it was intent to defraud, intent to permanently deprive these particular victims of their money that was going in. The detectives did a lot of background work, a lot of investigation. They put together witness statements. They worked with the victims to put together financial statements. They worked with the tax rolls and the property records to see who owned the property, who didn't own the property. But ultimately, what a jury has to consider is, what was the intent in the mind of a defendant? And unless a defendant has made a statement, or unless a defendant has come out with a particular document or sent an email or a text message, that's one of the more difficult things to determine. And without that criminal intent, what's going to happen is that the 6 jurors are going to go back to the jury room, and they're all going to sit there and they're going to say, look, we may agree that the victim was deprived of money in this particular case and that the defendant took the victim's money. But did the state prove their case? Did they prove beyond a reasonable doubt, not a preponderance? If this was a case that was a civil case, you just have to move the scale one way or the other. Is there sufficient evidence by preponderance that the defendant took the money from the victim? That much seems clear here. But all that's going to result from that is that hopefully the victim will get their money back, either because a court orders a defendant to pay the money back and then orders a defendant to pay attorney's fees, or you end up with a judgment. And unless you can enforce the judgment against a defendant, you're left with a piece of paper that says you're right. You're absolutely right. This person took your money. They had no right to take your money. But without a way to enforce the judgment, all you have is a piece of paper. And what are you going to do with that? Put that up on your wall and file it? In the criminal context, they have to prove beyond a reasonable doubt that it was his or her criminal intent to take the money. And how are they going to do that? They're going to have to look at the property records, and then they're going to have to show that the defendant either knew or should have known that he had no right to be holding out this property for lease, that the person who he claimed or he believed was the proper holder of title to that property wasn't the proper holder. Well, in this particular instance, based on the documents that you provided to me and that I reviewed, it appears that at one point in time, the person who was titled to property in this through a trust transferred some sort of title, and then that person then communicated with the defendant in this case. How do we know what was said? What do we know what was said between the two parties? The only way to prove what was said was to call one of these two parties and have them testify against the other, or provide emails, provide text messages, provide recorded phone calls as to statements that are being made by the defendant, which are an admission, which show the criminal intent. Not the I'm taking your money and then turn around and prove later by some type of evidence, by a preponderance, that he had no right to take the money, but actually show their criminal intent. And that's what the frustration was of the prosecutor, as he related in his closeout memo, where he said, yes, I believe that he had no right to take your money, but at this point, without more, I can't prove the criminal intent, and in order to convict this defendant, I need to prove the criminal intent. Now, the actions that the defendant alleged to have taken after the fact by making phone calls, which could be interpreted to be harassment or could be interpreted to be threatening to the victim, separate crime, having nothing to do with the money that was taken or not taken. If the victim has a recorded record of that, if the victim has email evidence, text message evidence, that needs to be presented to the police and to the prosecutors for potential criminal harassment, stalking, aggravated assault, or threats, or coercion, or intimidation, or witness tampering. And that's where the police and the prosecutors should be looking to see if there's any other enforcement action they could take against the defendant.